Thank you, sir. And we'll begin those questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and we thank the witness, probably the most important witness we'll hear from concerning this legislation, the Chief Electoral Officer. Now, you testified a few moments ago that when the rules changed in 2007, that it made things more challenging for poll workers and that some irregularities would have occurred. The evidence that we've heard before this committee this morning was that there were 50,000 irregularities in one case, and there was over 100,000 irregularities in another case concerning the last federal election. Now, you would know about those irregularities because you're the only person who has the authority to reopen those sacks that contain the evidence. I noticed you said estimates, so I imagine you didn't count them all. You made an estimate.
Yes.
And that 120,000 were vouching.
Vouch for.
Now, in all of those errors that were made, did you see any evidence or do you have any evidence to give to the committee on how many of those errors actually caused somebody to vote who should not have voted or fraud during that election campaign?
This whole matter is of errors came through a case, the Etobicoke election, which was contested and went through up to the Supreme Court of Canada. In the course of that case, there were issues raised regarding voter registration and voter vouching. A number of errors were pointed out to the courts in those cases, and in the end, the Supreme Court of Canada said that bookkeeping errors are not irregularities in themselves. And the vast majority of issues that were found were bookkeeping errors. So improper bookkeeping by electoral workers. There was no indication of two things. No indication of any malfeasance by workers. Secondly, the court was satisfied that there was no reason to believe that any ineligible electors would have been allowed to vote.
That's the important point, isn't it? Because that's what...
I would think so.
Well, you would think so. So all of these irregularities, probably involving a long-term facility in which the nurse probably vouched for a patient. Am I giving a good example here?
Yes, in a case, a nurse vouched for 29 electors.
Just imagine. Now, that's an irregularity. Shouldn't have done it.
No.
But no doubt that person had a right to vote. Now, let me get to the very important statement you made a minute ago. I'm going to quote you, because this is the disturbing statement you've made in your presentation. Overall, we estimate that approximately 120,000 active voters rely on vouching, and we can expect that a large proportion of them would not be able to vote under the proposed rules. You're telling this committee there's going to be tens of thousands of people who are eligible to vote in the last election, but with the passage of this bill will now not be able to vote.
Yes, because it's the only safety valve or fail-safe provision for people who are challenged in proving their identity and address. The only fail-safe provision is vouching.
And you
taking
use the
it away
eliminates
the fail-safe.
And you use the word fail-safe because, as I recall, in a BC court decision, that was the evidence that vouching was a fail-safe to somebody who didn't have the necessary documentation. Is that correct?
You're referring to the Henry case, I
Yes,
believe. Yes,
I'm correct. So, Section 3 of the Charter, you cannot deny somebody's right to vote. So this legislation, if we are to take you on your word, you have reasonable grounds to believe, to suspect, on a balance of probabilities that tens of thousands of people will not be eligible to vote who voted in the last election, then it violates Section 3 of the Charter.
Well, I think that's a matter for you to consider as parliamentarians as well. If a matter is brought before the court will have to determine whether it offends or not Section 3.
Well, you're going to be the respondent. You're going to be the respondent in the court
I'm going to be
case.
a party, but the Attorney General will be the respondent and defending.
But you're now agreeing with the applicant, because you're saying yes.
My role before the courts is to advise the courts of the current provision of the legislation, how we interpret it and how we apply it, and provide an information that may assist the parties and the court in determining whatever the issue is at hand.
Good
Here,
answer.
Senator Baker.
Good answer.
Move on to Senator Frum.
Thank you. Just to continue with that vein of questioning, you've taken the position that of the 120,000 estimated vouchers, we don't know. That's from Neufield's report.
No.
It could be less, it could be more, we don't know.
It's based, there was a methodology applied there, but it's based on 1,000 poll books being opened from a cross-section of representative riding and polling station across the country.
But by asserting that those approximately 120,000 people are going to be disenfranchised, it means that you know that they have no other form of ID. Can you say with certainty that you know that they don't have ID, that you know the reason why they were vouched for?
I can think of a few examples. The most, probably the easiest one, is with seniors living in long-term care facilities. Often they don't have documents.
But on that point, and to the 29 cases by one nurse, that's inappropriate. But the administrator of that long-term facility can write a letter of attestation that they live there, and that solves their problem.
Yeah, that leaves it to the goodwill of the administrators. In some cases, unfortunately, for very good reason, they have refused to provide those letters of attestation. There's no obligation for them to provide that. So we rely on their goodwill and try to negotiate a way of making it happen, but in some cases, for all sorts of good reason, it's not possible.
Moving to a different subject, your concerns about removing, from Section 18, removing your ability to participate in future and get out the vote initiatives. I want to ask you, do you not see why there is a conflict of interest between you as a chief electoral administrator being in charge of the administrations of free and fair elections, and also you being invested in get out the vote initiatives, so that you have then a vested interest in seeing the numbers increase, and that balance between you needing to see that things are free and fair and you as a motivator to get out, to make sure that voting increases, you don't see the conflict there?
I wouldn't say that we're involved in getting the vote out. That's not what we're doing. We don't do any of those activities during an election. But in between elections, we work with educators across the country, with various groups. We provide tools in schools to help provide the civic education for young Canadians. Generally, those initiatives have been very well received by teachers, by schools, by parents, and by kids. There's even some data that suggests that those kids who have gone through those civic education are 14% more likely to vote if they have gone through a proper civic education.
Yeah, I agree with you that civic education is important. I'm just questioning whether or not it's properly housed with Elections Canada.
My point here is that it should happen. I think it's essential that we inform future electors regarding their role in society and community and the importance of voting. If it's done by others, I'm fine. I think it's something that is required a concerted effort of the whole civil society.
But you have said that the measures in Section 18 will limit your ability to properly administer free and fair elections.
Yes.
So is that really, can you really extrapolate that we will not have free and fair elections if you can't do those civic
My
promotions?
concern is that the way the new Section 18 is written, it's written in a restrictive manner. The operative word in that section is only. You can only communicate with the public with how, where to vote and register or be a candidate. During an election, there's all sorts of incidents that happen where I think it's important to reassure Canadians that something is wrong or that something is fair. And I think if nobody can speak out to those issues during an election, I think Canadians become quite concerned about what's going on. I'll give you an example. I assume you followed the Quebec election recently. There was quite a dispute regarding potential non-resident trying to register and vote in that election. And that's what we do. Within 24 hours, we looked at all the data available. We're able to satisfy or reassure the public that there was nothing amiss going on. That's the sort of thing that an electoral body has to have the ability to do. Otherwise, confidence,
And why do you think that would no longer be allowed, that particular
because
example?
I cannot communicate on anything except where and how to vote.
But
That's 18.
And who can vote? You can communicate on who can vote.
I'm not sure that's what it says.
It is, but okay. Thank you, Chair.